What is Woodside Management et al. Versus Andrew Bruex et al.? Each side will have 15 minutes to argue. There are cross appeals involved here. You both know what each other is arguing, so handle your cross appeal and everything you need to handle in your 15 minutes. Actually, I guess that goes to Woodside. Wait a minute. Just thought of something. All right. Mr. Dickinson, are you going to be arguing, Mr. Bush?
Yes, Your Honor.
You can reserve time for rebuttal. And who's going to be arguing for Woodside?
Phil Downey, Boise State CMRP, Your Honor, thank you.
Thank you. All right, we have read your briefs and we are ready to begin. Just let me know if you want to reserve how much time.
Yes, Your Honor, I'd like to reserve 5 minutes. May it please the court, my name is Claire Dickinson. I'm here this morning on behalf of defendant appellants Andy Bruex, the Bruex Revocable Trust, and Bruex Properties LLC. I was here for your first argument where Mr. Williams told you what preparing for that argument reminded him of, and preparing for this argument reminded me of something. It reminded me of the movie Ghostbusters, the original movie Ghostbusters. 3 scientists in New York City are hunting down ghosts, and their weapon is called a proton blaster that shoots streams of, I guess, protons. And early in the movie, the one says to the other two, whatever you do, don't cross the streams, because if you cross the streams, something bad will happen. In this case, there are 2 separate transactions between 2 different sets of parties. There's the first transaction is the stock purchase agreement and the promissory notes that are part of that transaction. The relevant time period for that transaction, that transaction, by the way, was between what was then called B.W. Rogers, name was later changed to Woodside Management, on the one side, and Andy Bruex on the other side. The important dates connected to that transaction are 2011. The other transaction was a lease transaction. That was a transaction between Bruex Properties, LLC, and what was at that time called Industrial Logic. The name was later changed to Woodside Logic. The important dates regarding that transaction was when Woodside Logic purported to terminate the lease in 2014. So one transaction 2011 dates, one transaction 2014 dates. Andy founded Industrial Logic, built that company, built its business. It was in the business of providing industrial automation to companies and teaching those companies how to use that automation. And along about 2011, Andy realized that because of the pressures of the market, he was either going to have to grow that company a lot larger, or sell it to somebody else, or just kind of watch his business peter out. And he became familiar with B.W. Rogers, thought it would be a good fit, and so he decided to sell to B.W. Rogers. And they entered into this stock purchase agreement in October 2011. Rogers paid some money down, but also provided 2 promissory notes for the balance of that money. One of the provisions of that stock purchase agreement was that there were no hazardous substances on property that was owned, operated, or managed by Industrial Logic. Now, Industrial Logic didn't manufacture anything, it sold stuff. And it did it out of a building in Kalamazoo, Michigan. That building was located on an 11-acre lot. Industrial Logic leased part of that lot, the part that the building and parking lot were on, from Bruex Properties. We don't, well, I'm getting ahead of myself. It did not lease the entire parcel, leased part of the parcel.
1.5 acres.
Well, I started to say that, but I realized that the new lease, the new restated lease that started at the time the stock purchase agreement was consummated, provided for 1.5 acres. At least in relationship to my first assignment of air, the sufficiency argument, the lease that the previous company, while Andy still owned it, the lease from that period was not in the record during the plaintiff's case. So we don't know for sure, at least in connection with the first assignment of air, how much property was being leased. And so we don't know what part of that 11 acres could have possibly been owned, operated, or managed by Industrial Logic.
Are those leases, any of the documents, any of the exhibits in our record?
They should be. They were exhibits.
So the 2011 lease as well is going to be in there.
It became part of the record, I believe, during the defendant's case. Okay. And as I've already alluded to, my first assignment of air is sufficiency. It's that the trial court incorrectly denied our motion for a directed verdict at the close of plaintiff's case. We renewed that at the close of all the evidence. So in reviewing this assignment of air, the court is restricted to looking at evidence that was presented during the plaintiff's case. And as I've gone through in detail in the discussion of that assignment of air, there's the plaintiff's athlete's position is that there were hazardous substances on property owned, operated, or managed by Industrial Logic at the time the stock purchase agreement closed in 2011. The problem is there's no evidence that there was any substance on property owned, operated, or managed by Industrial Logic in 2011. They were required to prove that. In order to go to the jury on that question, they didn't present any evidence on that.
Was there anything in that lease that would have prohibited Bruex from depositing any hazardous materials subsequent to the lease being instituted?
I don't believe there was. There was no evidence that there was anything deposited or not deposited, for that matter. The business, as I said, the business of Industrial Logic was selling things, not manufacturing things. I want to talk about evidence that was presented about things that were there in 2014. There were a number of witnesses that plaintiffs presented who testified about substances present on the property, the 11 acres, in 2014. There was no evidence that anything there, except for things found, like the water in the building, was on property that had been leased, even in 2014, that was on industrial logic property. There was testimony about a dirt pile and some selenium found in the dirt pile. That dirt pile was out by dumpsters somewhere. We don't know if that was part of the 1.5 acres or not. And there's no evidence that that selenium was there in 2011. There was testimony about lead and copper in the water. The plaintiff's own experts all said, I can tell you what was there on the day I sampled. That's the only day I can tell you that something was there. And in fact, there was later testing of the water that showed the lead level had changed. It goes up and down. So the fact that it was there in 2014 doesn't tell us anything about what was there in 2011. The same was true of lead and silver in septic, if that can even be a violation. But what was there in 2014, no evidence what was there in 2011. I want to quickly move on to my fourth assignment of error. Is that telling me my total time? I'm sorry.
That's your total time.
So-
You're rapidly approaching your 5 minutes.
Okay. That
You
point, I
want to
think
keep it full 5 minutes.
I want to keep my full five.
All right.
Good morning, Police Report, Phil Downey of Woodside or Seymour Pease. I'm here with my colleague Andrew Grant on behalf of Woodside Management and Woodside Logic. I will jump straight into the points that have been discussed previously. If the court is looking for the actual lease that was signed in 2011, that'd be found in two different places. One is it's an attachment to the stock purchase agreement. I can't remember which, but it's listed as one of the schedules, which is important when I get to the choice of law issue that we'll deal with when we consider the claims about this lease. The actual executed lease in 2011 was, I believe, it was defense exhibit number 2. That's where you'll find the actual lease.
And are they part of our
Oh.
record?
I'm sorry?
Are they a part of our?
They are both part of our record. And I'm sorry, Your Honors, I jumped right into starting talking. I meant to reserve some minutes, some time for rebuttal. May I still do that?
No.
Okay.
You don't get rebuttal, so you get your full 15 minutes.
Okay, thank you, Your Honor. Let me go straight to the issues that have been talked about. One is the presence of hazardous substances on the property in 2011. And as you'll see, and as the jury saw when they heard all of the testimony at the trial, there was many excuses offered by Mr. Bruex as to why he shouldn't be held to the warranties that he gave in the stock purchase agreement, which is in section 3.21 of the SBA, and the SBA is Exhibit 1, admitted at the trial, so you'll find that in the record there. Of all the excuses that were offered relating to whether lead in drinking water is hazardous, whether arsenic in soil is hazardous, the ones they brought to this court are two. One being that, well, there's some uncertainty as to which property is covered by the warranties, and we're going to quibble about which property is owned, operated, or managed by ILC. And then the second is the timing of the evidence, the timing of when these substances were present.
I need to interrupt because
Sure.
your time is so limited and this case is so complex, but you just said correctly, the jury found all of the evidence and actually found Woodside's favor. I'm just going to call it the hazardous element issue.
Correct.
But Mr. Dickinson's argument is at the close of your case, that wasn't there. So clearly something was there for the jury to make a finding. Was it there at the close of your case?
It was indeed, Your Honor. We had presented, first of all, evidence of all of the hazardous substances that were found. There was lead and copper in the water that was flowing into the building.
In 2014.
That's when it was found, and correct, because it wasn't found previously. They were examining it in 2014. That's when it's found. The second thing is there was silver and lead found in the on-site septic system, the tanks that the septic system was out. There was lead and arsenic found in the in the soil above the septic system. There was selenium found in some construction pile that was contaminated. So these were some of the things we argued about, pointing out some of the hazards that were there. There was testimony about what was the property that was covered by these warranties. First of all, it's set out in the stock purchase agreement. The stock purchase agreement says this property owned, operated, or managed by ILC. Mr. Bruex, in the testimony that we elicited on cross-examination, part of which was reading to him some of the testimony he gave during his deposition, is that this parcel, and there's only one, the other testimony, there's only one piece of land there, one lot, was operated and managed by ILC. It wasn't owned by ILC. It was operated and managed by ILC. So the jury could conclude from that it was the entire 10 acres. If you wanted to take a step back and say, well, maybe it's only the building and the parking lot and 1.5 acres, which was the property that's covered by the lease, and the lease was in the plaintiff's case in chief because it was part of Exhibit 1, which is part of the stock purchase agreement. The on-site septic system was certainly part of that leased property. It can't be any question about it, because the opposite would be sort of silly to suggest that we leased a building and a parking lot, first with no way to actually get there except by helicopter. And then second is you don't actually have any water flowing into the building because it's an on-site well. Well feeds the water supply to the building. So if you're going to say the well isn't covered, then how are you getting water into the building? And you can't flush the toilets because the on-site septic and the septic system, the leach field, is what serves the waste of the property. So if you indulge in these fictions about confining what the property is, all you do is reach silly arguments. And this is why we go back to what the jury's job is. Yes?
But when the lease was entered into in 2011, what evidence is in the record that would demonstrate what the status of the well and the septic system were at that time?
There's two things. One, there's evidence of what was there in 2014.
I want to know what was there in 2011. What evidence is there about what the situation was in 2011?
Well, there is evidence of what the historical use of the property is. And here, I'll answer your question this way. This is the flaw in the other side's argument. It's that our burden is to somehow show the exact date that these contaminants showed up. That's not our burden. Our burden to show the contaminants were there in 2011 when the stock purchase agreement was signed. So what the evidence, what it included is, number one, no evidence that it was put there by anything that Woodside Logic did when it started occupying the property in October of 2011. So there's no evidence that Woodside Logic contributed to it. Mr. Bruex said nothing that he did contributed to it. Mr. Bruex said that he's not aware of anybody dumping anything onto the property between when the lease, when the stock purchase agreement was entered into and when it was found in 2014. So now you have evidence that there's nothing contributing to the contamination during that time period. And then what?
Excuse me,
Yes.
wasn't there actually testing done in that 2011 timeframe before all these documents were signed?
What there was something called a Phase 1 environmental assessment, which was done and jointly paid for by the parties, covered the entire 10 acres. And what it essentially, I'm just paraphrasing, but it is an examination of the history of the property to identify potential sources of contamination. And there's a report that was created, and this was somebody that was hired by Mr. Bruex and paid for by the parties under the terms of the stock purchase agreement. It is in the record. It's Plaintiff's Exhibit 6.
It's in the trial court record.
It is in the trial court record. Correct. It's in the record of the trial. It is Exhibit 6. It says the property is 10 acres. It says the property was historically used as agricultural land until it was purchased and developed. And that's important because other evidence, including testimony and reports by Mr. Villa, indicated that lead arsenic was something that was used as a pesticide on agricultural land, and that would account for why there was lead and arsenic found on this property. He also said it was his conclusion that it would be throughout the property, this contamination, number one. Those also would demonstrate that here's more evidence of the why it is these contaminants that were not discovered until 2014 were actually there in 2011. So all of this.
Why wasn't a phase 2 done then, back in 2011?
Well, I can't speak to exactly what was in Mr. Brooks's mind, but what was provided at the closing were two things. One, the phase 1, which didn't identify any existing contaminants, and then number 2, a complete warranty by Mr. Brooks. Mr. Brooks warranted and represented in the stock purchase agreement that there were no hazardous substances on the property. And hazardous substances was very broadly defined in section 3.21. So there's no reason to do a phase 1 if you're the purchaser because, I'm sorry, do a phase 2 examination because you have the phase 1 report and you have a complete unrestricted warranty of Mr. Brooks. So as a result of those things, then the parties went forward and closed. I think I touched on the issue of the 10 acres. One other part of the evidence that was presented was the fact that the entire 10 acres was taxed as one parcel and then Industrial Logic paid the taxes, and which is another indication that the entire property was covered by the lease. The entire property was operated and managed by ILC, and therefore the warranties applied to the entire property. For the court's ease of reference, if the court wants to see exactly how the property is configured and how close things like the well and the on-site septic system are to the building, the court can look at Exhibit 8, which is one of the reports of one of the environmental consultants, and on page 21 is an aerial photograph that has indications of where some of the testing was done.
In the trial court.
Exhibit 8 in the, I'm sorry, yes, in the trial record. That's what that is. Again, plaintiff's Exhibit 8. And I'd say finally that all of this discussion about what the property was, it sort of ignores the fact that the contamination was also found inside the building. It's in the water. And so why we're arguing about what property is described by this or described by that is just sort of a red herring. But ultimately, this is what we have jurors for. We have jurors present the totality of evidence, and when we get to a question, like you do here, of sufficiency of the evidence, what is the standard that the trial court is required to apply? Consider the totality of evidence, view it in the light most favorable to the non-moving party, allow all inferences to be drawn in favor of the non-moving party. So with all of that evidence and all of those legal requirements, and to the extent there's differentiations between direct evidence and circumstantial evidence, the law says all of that is equally to be considered. So that's what was presented, and therefore it was perfectly correct for the trial court to deny any directed verdict motion on that issue, and there was certainly more than sufficient evidence at the close of the case and when the jurors decided this, for the jurors to decide that a warranty was breached. As a result, I believe that takes care of the assignment of error number 1 of the appellants, which is challenging the sufficiency evidence on count 2 and of course judgment on count 2. If there's no other questions on that, let me go to a couple of other issues. One of the issues that hasn't been argued yet, but maybe is the trial court's award of attorney's fees to Woodside Management, which was pursuant to the plain language of the stock purchase agreement. The stock purchase agreement states that when Mr. Bruex breaches, or in the event he breaches one of the representations and warranties, Woodside Management is entitled to recover the damages it incurs, including attorney's fees. That's what happened. Mr. Bruex breached the stock purchase agreement. Woodside Management incurred damages. Those included attorney's fees, and Woodside Management is entitled to recover them. And that's exactly what happened here. So it's supported by the contract and supported by the evidence. So what do we hear in opposition to the trial court's award? One is that somehow the declaratory judgment statute applies to this claim and limits the recovery of fees. It does not. The claim is a claim for breach of contract and action at law. It's count 2 of the amended complaint of Woodside Management.
2 questions on
Yeah.
that. First of all, was the amended complaint ever made part of the record? But you don't have to answer that. The more important question is, count 2 is for damages.
Correct.
How is damages a standalone claim?
it's a claim for breach of contract and damages for breach of contract. So it's not a claim for damages by itself if you, I'm sorry.
All right,
Okay.
go
I
ahead.
mean, the claim was for breach of contract and it alleged, I don't have the complaint sitting in front of me. And it is part of the record, Your Honor. It was filed when the case was in federal court and then was remanded. And I think we addressed this with the court prior to when we came in today.
It was provisionally accepted.
Yeah, and I'd be happy to address that further if the court would like us to address that further. But it was a claim for breach of contract, and that was the claim tried, and the trial court instructed the jury on the elements of breach of contract, the existence of a contract, substantial performance by the party bringing the claim, breach by the alleged breaching party, and damages approximately caused by breach. And that was the instruction, and the jury concluded that there was a breach, that we performed, and that we've been damaged as a result. When I say we, I mean Woodside Management. What made it a little bit unique here is that the stock purchase agreement gave Woodside Management the right to set off damages against amounts due under the promissory note. Doesn't take it from being a breach of contract claim, doesn't change the character of the damages as damages. It just means that it has that extra right. And I point that out because the exercise of the right of set-off doesn't, according to the plain language of the stock purchase agreement, constitute a waiver of any other rights of Woodside Management. And that's the part of the contract that the appellants want you to read out of the contract, because they say because we'd exercised the right of set-off and we didn't recover any additional damages, somehow we didn't prove our claim on count one. And that's just plain wrong, unless you rewrite the stock purchase agreement to take that out, which I don't think any court should do, and this court should not do. So by proving our position on that claim, we're entitled to recover attorney's fees. The last argument against it is somehow we were not the prevailing party. And as I understand the prevailing party argument, it is based upon the suggestion that the amount that the jury decided we were entitled to set off was less than what the judge ultimately entered in the way of a judgment for Mr. Brooks on the note. I'm about out of time, so I'm not going to be able to address that in much detail. But all I would say is the jury said we didn't breach the note. The jury said nothing was due. It was wrong to award a judgment for Mr. Brooks, notwithstanding the jury's finding. Thank you.
All right, thank you.
Just to clarify something, the lease that Mr. Downey referred to as being in the record and being part of the plaintiff's case was the lease that was entered into in 2011 going forward. The question about property owned, operated, or managed by Industrial Logic was property that had been owned, operated, or managed by Industrial Logic before the transaction where that company changed hands, or the assets changed hands. So the lease between Industrial Logic and Brooks Property from prior to 2011 was not in the record. And that would be the lease that would tell you what property was Industrial Logic owned, operating, managing at the time the transaction closed. That would be the relevant lease, was not part of plaintiff's case. The question about phase two, Mr. Downey said, well, I don't know what was in Mr. Brooks's mind. The question is, what was in Mr. Rogers' mind? When Common bought from B.W. Rogers, they had a phase one done, they had a phase two done. They wanted to know, are there any hazardous substances on this property? Mr. Rogers was content with not having a phase two done. If he had had it done, we would know whether there was a hazardous substance there in 2011. Since he didn't, we don't know. They had the burden of proving there was, they failed. On the question of attorney's fees, very quickly, the first count was a count for declaratory judgment. The second count was breach of contract and a request for damages as a result of breach of contract. They got their declaratory judgment. The court entered a judgment saying, yeah, the money that was set off, $48,000 of it was legitimate. They didn't recover any damages. They didn't recover anything on count two. But they're saying that somehow that they're entitled to attorney's fees on a count where they failed to recover anything. If they got anything on count two, it was a reiteration of the declaratory judgment. And the declaratory judgment statute clearly provides you don't recover attorney's fees on a declaratory judgment. The 2 minutes I have remaining, I want to just very quickly address my fourth assignment of error, the damages on the breach of lease. The jury determined that Woodside was not within its rights in purporting to terminate this lease and move off the property. The jury determined that was a breach of the lease. The problem is that when they calculated the damages, they lost their way. They created a manifest misjustice. At a minimum, Mr. Bruex should have been entitled to the monthly amount called for in the lease, at least up until the time of trial. But the number given by the jury, $186,745, was less than even that amount. If you had just calculated the monthly rate up to the time of trial, that would have been $218,000. It's not a matter of the jury determining that Mr. Bruex had failed to mitigate, because the jury was asked, and the jury, how much did Mr. Bruex fail to mitigate? It said 0. So what I am asking for on that fourth assignment of error is a reversal just on the question of damages, and for a remand to the trial court so that we can have a new trial on the question of damages for the breach of lease. And with that, I'll answer any questions anybody may have. And if not, I will sit down.
I have more questions that I can go with, but it's,
I have inferred from your questioning, Judge Callahan, that maybe the exhibits didn't make their way over here.
you have inferred correctly, so I'm just giving everybody the heads up.
And I would like to move for leave to get them over here.
There was a method to my madness in bringing that up repeatedly.
So I hereby move.
I guess I'll be sitting here presiding today, so hereby granted.
Thank you.
Thank you, Your Honor. I would just say, I didn't realize that there was a question about the trial exhibits not being here either.
Arguably, it's a mistake on our part.
Well, we'll make sure they get here.
Thank you, Your Honor.
Thank you much.
Thank you.